New York does not recognize a constitutional or common law right of privacy, such as claims for intrusion, false light, publication of private facts, and misappropriation. Privacy is, however, regulated statutorily through the civil rights law, although courts narrowly construe this right to only prohibit the commercial appropriation of a person's name, portrait, or picture without written consent. The New York Attorney General's Bureau of Internet and Technology and the Bureau of Consumer Frauds and Protection are currently tasked with overseeing enforcement of the law. However, this limited general data protection regime is going through a process of change. On the 8th of January 2020, in the wake of the California Consumer Privacy Act, or CCPA, a bill for the New York Privacy Act was reintroduced to the New York Senate Consumer Protection Committee. The New York Privacy Act is aimed at improving transparency, strengthening the protection of individuals' personal data, and establishing a private right of action for individuals to sue companies for violations. Like the CCPA, the New York Privacy Act would apply to all legal entities that conduct business in New York State or produce products or services that are intentionally targeted to residents of the state. In addition to this, the Act would provide data subjects the right to information, access, rectification, and erasure, and would propose a new definition of personal data, which includes, among other things, biometric information, internet, or other electronic network activity. Organizations should also take note of New York's recent Stop Hacks and Improve Electronic Data Security Act, commonly known as the SHIELD Act, which amended the state's data breach laws and entered into force on the 23rd of October 2019. In particular, the SHIELD Act strengthens obligations to notify affected consumers in the event of a data breach. On top of widening the definition of a data breach and updating the breach notification requirements that companies and state entities must follow, the SHIELD Act also broadens the scope of information covered to include biometric information and email addresses with their corresponding passwords or security questions and answers. The SHIELD Act is also likely to affect a much wider range of organizations, as it extends the notification requirement to any person or entity with private information of a New York resident, and not just those who conduct business in New York State. The SHIELD Act provides that businesses have until the 21st of March 2020 to ensure their compliance with these amendments. In addition to the New York Privacy Act and the SHIELD Act, the New York State Department of Financial Services final regulations on cybersecurity became effective on the 1st of March 2017 and mandates cybersecurity standards for covered entities authorized by the NYDFS to operate in New York. In particular, they require banks, insurance companies, and other financial services institutions regulated by the NYDFS to establish and maintain a cybersecurity program. They are also broad in their scope, including numerous prescriptive requirements which range from access controls and encryption to data disposal and employee training. With the SHIELD Act already affecting businesses in New York and the reintroduction of the New York Privacy Act, the data protection regime in New York is entering a period of anticipation and change. As is the case in many other US states, it remains to be seen how these developments will progress. However, as the extended scope of the SHIELD Act suggests, data protection regulations in New York are likely to have a significant impact both inside and outside the state. To continue researching key compliance requirements in New York, use jurisdiction dashboards to quickly access the latest regulatory developments and best practice from leading experts.